Yeah, please go ahead.
Okay. So good evening to everyone and to our guests also, Dr. K.S. Kardam, Dr. Malathi, Professor Ghosh, and our professor in charge, Professor Aman Mittal. So the topic which we have selected uh, has great relevance, and given the uncertainty over the scope of diagnostic patents, not only in India, but in other jurisdictions also, it becomes very important to discuss about the uncertainties. We may not provide, you can say, complete solution, but we may tend to that. So that is our approach, that we must clarify the uncertainties and try to explain those, that what are the main hurdles and whether we are approaching the real problem, or we are just moving around and hitting something which is not the core of this very problem. So having said that, I mean, the diagnostic patents are playing very important role in the innovation in the field of diagnostics, but it has been excluded in certain jurisdictions, and the mandate came from the TRIPS agreement, which gives a leeway to the countries to either exclude it or may contain it. So it is explicitly written in 27.3a, Article 27.3a, that members may exclude from patentability diagnostic, therapeutic, and surgical methods for the treatment of humans or animals. So there are jurisdictions like US, where the jurisprudence of diagnostic patent evolves through the case laws. And recently, after the Mayo decision, till 𝐂𝐿-𝐶𝐶 decision, I mean Erosa versus 𝐂𝐿-𝐶𝐶, there was a tightening up of the patentable subject matter, and against this very approach, judicial approach, there is a proposed draft bill uh, which has been floated by certain legislatures also, legislative members also, uh, to rectify the judicial decision which has been given in a series of decisions, like may it be Mayo, may it be Association of Molecular Pathology versus USPTO, or ERISA versus 𝐂𝐿-𝐶𝐶. And there were a registered reluctance of the diagnostic, you can say, companies also, which were once upon a time very enthusiastic to go for patents. Now they are a little discouraged regarding that. If you compare the situation with the European Union, I mean, this very approach is very much, you can say, differing from one jurisdiction to another jurisdiction because of the mechanism and laws which are there. So if you go by the relevance of this very diagnostic field, 66% of clinical decisions are based on guidance provided by in vitro diagnostic tests. And if you don't incentivize this very industry, then the stake of the industry would be in jeopardy. And because EU explicitly maintains that in vitro is allowed, but in vivo is not allowed, that is a clear position which they take, and they progress on the same line. If you compare it with India, I mean, in section 3I, which comes under what are not inventions, I mean, it is explicitly provided that any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products is not considered to be an invention. So here, whether we are going by the technical criteria or we are going by the policy considerations while recognizing these exceptions or exemptions, that we have to look into. There is a rationale behind these exclusions because it ensures the accessibility and availability of these products or the methods. But on this, at the same time, we have to make sure that the I mean, companies which are doing some research, which are involved in certain human ingenuity, their ingenuity must also be recognized. So when we interpret these very exceptions or exemptions, we must have a balanced approach. And patent, which is supposed to be a balanced system, this could be, I mean, taken care of. So I'm just, setting this very background for the further discussion. So I will be, following an order of this very discussion. So I will start with Professor Shubha Ghosh, then followed by Dr. Malathi, and lastly, Dr. Kardam. And before we proceed, I invite our professor in charge, Professor Raman Mittal, to give a welcome speech. So, thank you.
Thank you very much, Dr. Kshitij, Professor Shubha Ghosh, Dr. Malathi Lakshmikumaran, Dr. K.S. Kardam, Dr. Kshitij Kumar Singh, Sri J.P. Meena, Sneh Yadav, my colleagues, and dear students. Today we have gathered at this digital forum to discuss something which is of great importance in the field of law relating to patents. We shall debate on the topic of diagnostic patents, especially in the light of Section 3I of the Patents Act. Section 3I, as mentioned by Dr. Kshitij, states that any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products is not an invention. Even though it may be new, it may be industrially applicable, or it may conform to all the requirements of patentability. Therefore, Section 3I is styled as an exception to the general rule of patentability. To recognize an exception is to reach outside the rule to dispose of a case. For to recognize an exception to a rule is to preserve the rule, not to change it. As Fred Schorner says, the exception is an invisible topic in legal theory, one about which it has been thought that no interesting generalizations are to be derived, despite the fact that exceptions surface almost everywhere throughout the most legal system. I have heard of at least 4 types of statements that demonstrate the relationship between the rule and the exception. The very idea of an exception is a topic of potential philosophical, theoretical, and jurisprudential interest. As lawyers, we are subsumed with rules, rules of various kinds, and rules for various situations. Since any rule is subject to many circumstances in which the rule will fail to apply, every rule will have a number of unarticulated conditions that constitute exceptions to it. Therefore, we hear of a phrase, every rule has an exception. Every rule has an exception. When a teacher of law was narrating this statement to his first year's law class, a young student raised his hand and said, "Sir, I know of a rule that has no exception." Well, the teacher replied, "That is an exception." The second statement that we often hear is, exception proves the rule. Exception proves the rule. Now the question arises, if an exception cuts through the spectrum of a rule and diminishes its sphere, how does it stand to prove it? Well, the phrase that exception proves the rule is at least 2000 years old and is attributed to a maxim of Roman law. One of the archaic meanings of the word prove is to test. So to prove means to test. That means an exception tests the rule. In this sense, the phrase does not mean that an exception demonstrates a rule to be true or to exist, but that it tests the rule, thereby proving its value. The third statement that we hear is that the rule has swallowed the exception. The rule has swallowed the exception. This is the idea that the myriad qualifications that apply to a rule without being included in a statement of it, do not in fact fall outside the scope of the rule. They are an implicit part of the rule, despite their formal exclusion from the statement. For the ones excluded, they lurk within the rule anyway. One has only to read between the lines to see the rule has swallowed the exception. Okay, I think there was some problem in the connection. Am I audible now?
Yeah,
Yes.
Also.
Okay, so the fourth one that we hear is that the exception has eaten up the rule. This seems contrary to the third one. An example would be the father saying to his son, "My dear son, you are free to marry anyone. You are free to marry anyone, but the girl has to be of my choice." Well, after these four statements, there is a question whether the rule came first or the exception came first. I would say that the exception came first. Because at a time when we had not yet made the rule, everything was in the color of exception. Everything was in the domain of exception. My dear friends, to explore the dynamics of rule-exception relationship in the context of diagnostic patents, we have invited leading experts in this area of study, and we are extremely grateful to them for having taken time out of their very busy schedule. Thank you so much. Over to you, Dr. Kshitij.
Thank you so much, sir. And you reflected the value of exception, and it must be valued in the first place. There is no doubt about that. But how you interpret the exception, again, I'm just going to that very point, is always worthy to provide scope for any industry, or you can say economic growth also. So, I mean, one should not, you can say, dilute the value of exception in the name of progress, because that is also meant for some social purpose. So that may be taken into, must be taken into account. But having said that, we should also take care of the other aspect where its proper interpretation give way for more and more development. So thank you so much, sir. So I will be inviting next Professor Shubha Ghosh, who is a Crandall Melvin Professor of Law and Director of Syracuse Intellectual Property Law Institute. He has a JD with the distinction in 1994 from Stanford Law School and PhD in economics from University of Michigan. He graduated from Amherst College and is one of the authorities in IP in USA. And he touched upon all the technologies, almost all the technologies, may it be information technology, biotechnology, so on and so forth. And particularly, he wrote on precision medicine, a book published by Cambridge. And he took these concerns very seriously. So having said that, I must, highlight, observation from the Sequinum case only, where the senior Judge Lin concurred separately by saying that he was bound by the sweeping language of the test set out in Mayo. So he considered that that was a kind of compulsion on him. And he made a remark that the breadth of the second part of the test was unnecessary to the decision reached in Mayo. The case represents the consequence, perhaps unintended, of the broad language, excluding a meritorious invention from the patent protection it deserves and should have been entitled to retain. So it means to say that the decision which came through Mayo I will be very much interested, and everybody will be interested, that what was the real reason for that, and whether it was apt or not, whether it was on the progressive track or not, and why this very legislative effort was sought to rectify this very decision. So on these 2 points, and I will be looking forward from Professor Ghosh. So I'm inviting him. So please, sir, the floor is yours.
Okay, thank you. I'm going to be sharing my screen. Hopefully everybody can see it.
Yes.
Yeah, let me move one thing here. Okay, I'm trying to start the slideshow here. Stop share. Okay. Okay, I hope everybody can see. Can everybody hear me?
Perfect.
Well, thank you for organizing this early morning conference for me on Saturday. Hope everybody's enjoying the evening there. I appreciate the interactions, and thank you, Dr. Singh. Thank you, Dr. Mittal, for inviting me. So we've had an interesting. I'm a bit confused now as to what rule or exception means anymore, but we have this notion, I guess, the idea that every rule is an exception is itself a rule. I don't know where that rule came from, but we live with it. But I think before even we get to this question of rule versus exceptions and how they fit into TRIPS, we need to think about the broader background, and that is policy, and probably even the politics. And so when we look at the medical diagnostic patents in the US, and the discussion I'll do will focus on some of the cases that that Dr. Singh mentioned, both Ariosa and follow-up to Ariosa. You know, the interesting issue that you see in these cases is the way in which medical diagnostics have this special place between a physical and abstract space. And as we'll see, the more recent cases involving medical diagnostics in the US have really tried to emphasize the physical, the specific, the concrete, largely because the earlier cases, especially Mayo and Alice, were tried to concern with the abstract. And so why is there this notion of physical and abstract? As we'll see, as we look at some of the more recent cases, this focus on the word specific. Specific comes up quite a bit. Why is that? Largely, there's a concern about policy. The concern may be reflected in the TRIPS agreement. It may go back to concerns with the patent statutes and the potential monopolistic or competition aspects of patent law that go back maybe to the founding, even go back to the statute against monopolies. And so, you know, we see this. We've actually, even in the U.S., it's very interesting with President Biden recently having an executive order, really pushing the executive and also indirectly pushing the legislature to look at more policies about competition. And he had the famous statement in his speech, I believe, yesterday, that capitalism without competition isn't capitalism. And so this is the notion that comes up in patent law. Of course, within the statute of against monopolies, the 2 exceptions were for copyright and patents, but they were not meant to necessarily be complete exceptions. And I think ever since then, you know, there's been a discussion about what exactly is the role for patent law, how broad should the rights be, and what we do when the rights seem to get too broad. And so those are the policies, and those get caught up in the politics. And what I mean by politics is just the institutional interaction among the various parties that have the authority to deal with patent law. And so in most jurisdictions, that would be the patent office, of course, as well as the courts. Within the US, obviously you have the United States Patent and Trademark Office, as well as the courts. But the court system is a bit more complicated in the sense that we have the United States Supreme Court, And then we have the Federal Circuit, the United States Court of Appeals for the Federal Circuit, which is a specialized appellate court that deals with patent appeals. It can deal with other issues as well that are attendant to patents. And so you have this dynamic between the Federal Circuit and the United States Supreme Court that's also reflected in these cases that Dr. Singh referred to briefly when he cited Judge Lynn's language from Arioso about how, well, maybe we'd like to do something different, but we're bound by the very broad language of the US Supreme Court, which is a very non-humble way of being humble, the way in which I think many lawyers and judges have the habit of exercising quite well. Basically, I don't agree with the Supreme Court, but I'm not going to say that expressly. I'll just simply follow them and let them see what the absurd consequences of their decisions are, is how I read Judge Lynn's statement. But that dynamic between the Federal Circuit and the US Supreme Court is an interesting one. Sometimes it's overplayed. We like drama in the United States. We like drama on television. We like drama in the movies. We like drama in the law. Maybe that's happening in other countries as well. Certainly, I have that feeling that might be the case in India. But that particular dynamic between the Federal Circuit and the US Supreme Court would be interesting to trace. Certainly, we don't have that in India. And certainly, there are other jurisdictions that do have specialized trial and appellate courts that deal with intellectual property. So, but even there, we don't see the same sort of issues that we're seeing in these types of cases in terms of how we deal with patentable subject matter. Partly because the patentable subject matter in many other jurisdictions are handled by statute, as we see in 3I in India. The legislature has made a decision about exceptions, but the exceptions that we're dealing with in the US are largely judge-made. And so this is the dynamic between the judiciary and the legislature. And even the US Patent Office follows, sometimes it does do rejections based upon exceptions that it creates, but the US Patent Office in general has followed the statute and has really looked for lack of novelty or lack of inventive step or lack of enablement in terms of rejecting patents. And it's only when we have the courts making decisions regarding subject matter that we see the patent office then responding in terms of how to deal with subject matter. Now, there's one big exception to that, and that may be the exception, to go back to Dr. Mittal's point, that proves what I'm saying, and that had to do with business method patents in the 2000s. This case called Bilski versus Kapos, which originated, within some very interesting issues within the patent office that I'll make some allusion to. So let's look at the structure, look at the dynamics, and talk about some of the cases and where these come from. So within the United States, we have the statute, which talks about patentable subject matter in terms of in 4 categories. It has to be a manufacturer, it has to be a machine, it has to be a process or a composition of matter. And I italicize the word process because that's the concern here that we're seeing with medical diagnostics. Medical diagnostics are viewed as a type of process. The notion of a process patent, we have this codification that occurred in 1950 with the patent statute. But the notion of patenting a process goes back to the 19th century, to the late 1800s, with the development of chemical processes and the development of chemical patenting. And of course, over time, over a 100-year history, the word process has been expanded to not only include chemical, but physical processes, biomedical processes, and then of course in the information age, different types of computational processes and so forth. So the notion of process is definitely more diffuse, more open than a manufacturer, machine, and composition of matter. So it's not that surprising that we've seen the case law that has developed regarding process. And as I mentioned, the medical diagnostic cases that I'll discuss arise from how do we limit or how do we understand the scope of what a process is. But these notions of these limitations that we see in the statute need to be understood against the judicial exclusions, because unlike in India, there are no exceptions for subject matter within the statute. There are limitations that arise, for example, in the context of infringement, that arise in the context of licensing, but none that arise in the context of patent prosecution. These arise from judicial exclusions that are the following. These go back, have been traced back again to the 19th century, but had clear articulation in 1980 in the U.S. Supreme Court case called Diamond versus Chakraborty. But each of these exceptions also has a very intricate history that I'll be glad to discuss in questions and question and answers. But the three exceptions that we usually think about that are articulated in the courts: law of nature is not patentable, natural phenomenon is not patentable, and abstract ideas are not patentable. And specifically within abstract ideas, we see an exception for mental steps. Pure mental acts are not patentable. And this idea of an exclusion for process implicates all of these exclusions. But as we'll see, it's really the notion of abstract idea that is often cited in the context of process patents and their limitations. So we will focus largely on the third of these exclusions, but the other two matter as well, and they will come up, especially when we look at Ariosa versus Sequinon. So how do we understand the connection between the judicial exclusions and the patent statute? Well, this occurs through litigation. Now, with the American Vents Act in 2011, we've had some more additional administrative procedures where some of these issues are now getting litigated within the Patent Trial and Appeal Board, the PTAB. But it's largely been within the judiciary, and that's historically where the interaction has been between the statute, the legislature, and these exclusions that go back to the judge-made common law. And so the big decisions that affect medical diagnostic patents are, as mentioned by Dr. Singh, the Mayo versus Prometheus case from 2012. And this is a medical diagnostic case per se, having to do with adjusting the dosage based upon certain correlations in treatment with statistics and biomarkers that arise from a particular patient. And even though the court doesn't directly talk about mental steps, they talk about abstract idea, they focus on the language in the patent claim about correlation, correlating. Again, the case, I read it as one largely about mental steps, that the abstract idea here that was attempted to be patented is one based upon a pure mental process, and therefore should escape patenting under the judicial exception for abstract ideas, specifically mental steps. 2 years later, it's important to emphasize you have the Alice versus CLS Bank case, which then tried to look at processes more broadly. And so it extends Mayo to business methods and software-based processes. The particular invention at issue in the Alice case had to do with a method for applying for loans and processing loans through communication technology, information and communication technology. And so from here, we get what is really the Alice test, or sometimes referred to as the Mayo-Alice test. It's worth emphasizing, however, how these decisions came about. And so here we see some very interesting history from, this period from about 2010 to about 2016 or so, maybe still continuing, but really during that 5 to 6 year period, we saw the Supreme Court very active in this area about exclusions from patenting. One of the big cases here, of course, is the Myriad case that was decided roughly between Mayo and Alice in 2013, having to do with DNA, isolated DNA sequences. But this really started in 2010 with the US Supreme Court decision in Bilski versus Kapos, which had to do with business method patents. And there the court narrowly, very narrowly avoided, I think basically by one vote, Justice Kennedy switching and the court alignment on this issue. But very narrowly in Bilski, the court avoided creating an exception, a per se exception for business method patents. Instead, what the court did in its majority opinion is rely upon the exception for abstract ideas that it had historically to say that an abstract idea, such as the business method patent at issue in Bilski, is not patentable. The interesting issue is how Bilski originated. And often Bilski is thought about as a case in which the Supreme Court was putting down a decision by the Federal Circuit, and that is narrowly true. I mean, the Supreme Court was looking at a specific test that the Federal Circuit was developing for business method patents and maybe process patents more broadly, called the machine or transformation test. And the Supreme Court rejected that test from the Federal Circuit, largely because it wanted to rely on more traditional exclusions and was wary about creating new tests or new rules. Again, to echo Dr. Mittal's comment, what do you do with new rules? Should we have new rules, or should we just rely upon existing exceptions? And the Supreme Court in the US has typically avoided new rules and relied more on trying to find standard traditional exceptions. But what's the real origin of Bilski? I just want to point out the real origin of Bilski was in the US Patent and Trademark Office, where the US Patent and Trademark Office itself was concerned about patents on business methods and other so-called frivolous patents. There were several newspaper accounts and several scholarly accounts about frivolous patents that went back to the late 1980s, late 1990s at least, with the famous one-click patent that we saw with Amazon in the late 1990s, a business method patent. But then there's so many, jokes, and it was like a punchline that the U.S. Patent Office was just giving patents on anything. So the U.S. Patent Office was concerned, and so you did have a rejection within the U.S. Patent Office, and then it went through the U.S. Patent Office up through, of course, the Federal Circuit and then the U.S. Supreme Court. But here you had the U.S. Patent Office trying to adopt, roughly around 2005 or so, a European Patent Office approach. So they're looking for things like a technical effect and, really adopting the technical effect at the administrative level, which eventually didn't go anywhere. Obviously, now we have the Supreme Court decision in Bilski, and then following up 2 or 3 years later with Mayo and Alice, that creates this new test for processes. I mentioned this thing about the U.S. Patent and Trademark Office just to give you a sense of how important the U.S. Patent and Trademark Office is, but at the same time, how much it just simply follows, and how much patent law is based upon how the court decisions work within the United States, which I think is somewhat unfortunate. I would like the U.S. Patent and Trademark Office to be more of a forefront in trying to define these exceptions, using whatever rulemaking authority it may have or actually may not have in order to try to give more guidance. Because of the various actors that we've discussed, the agency, the legislature, the courts, the U.S. Patent and Trademark Office comes the closest to having actually the requisite expertise to give us some guidance of what patent law should be, but it seems to have the least voice in terms of affecting this. Now, I may be wrong about that. Maybe it has in terms of specific decisions about what patents to reject or what patents to grant. And maybe with the PTAB system, the agency is getting a little bit more voice, but that's to be seen. I'm obviously giving a little bit of the background that we've seen historically for these decisions regarding medical diagnostics. So you have the Mayo case, And the Supreme Court test, I'll skip one slide, the slides are a little bit out of order, I know this, is a two-part test. Step one is you ask whether the claim is directed to one of the judicial exceptions. So does the claim, does it seem to cover a law of nature, a natural phenomenon, or an abstract idea? If it does, then we get to step two. Does the claim transform the exception into a patent eligible application? And so the patents in Mayo and Alice failed this test. And so people look at this test and, we see, again, the court, is it creating a new rule? Is it just articulating or re-articulating its old rules in a different shape? Is it creating a new exception? What is it doing here? I think this test has been heartily and probably correctly criticized as not really being very helpful. I mean, as far as step one, it either covers everything or covers nothing. Because if we think about the exceptions, laws of nature, natural phenomenon, and abstract ideas, we can think about those as the building blocks of any invention. So that means any invention will, in some sense, have an abstract idea, a natural phenomenon, or a law of nature included within it. I mean, if it's a building block, it's hard to avoid those things. So it's not clear what step one is actually asking the agency or the courts to identify. If it simply means that the claim is just simply being swallowed up by one of these building blocks, then why not just simply apply the traditional exemptions directly? So if the claim is a natural phenomenon, really, it's covering a natural phenomenon, then just apply the natural phenomenon exemption, much like what the court did in Myriad, right? Myriad, they were looking at the natural phenomenon exception to say that, correctly or incorrectly, as we might disagree, that the isolated DNA sequence is a natural phenomenon and therefore should not be patent eligible. But if it is one or the other, it's not clear how step one does any work here. Then you have step two, which is trying to look at things like, is the claim transforming the prohibited judicial exception? But then it's asked, is it transforming it into a patent eligible application? And so now we have a test for patent eligibility where step two is asking, is this patent eligible? So I think, I think one of the things we teach, even before law school, but maybe it's really emphasized in law school, but one of the things we know is that a good definition does not just simply use the word in the definition, right? We don't say, to take an example I had from a statistics professor, if you want to bake a cake and you have an instruction for baking a cake, step one should not be, and certainly any step should not be, get a cake, right? No, you want to end with something, you want to end with the conclusion as to whether something is patent eligible. But step two is asking you, is this patent eligible? And so the test is not really doing anything, really. And I think that's probably a correct criticism. I think what the court is trying to do, the US Supreme Court is trying to do with these two-step tests is trying to offer some guidance at a very abstract level. It might be aware of its lack of competence as a technical court, but it's trying to say, well, here's how we should approach these matters. But again, it's doing it at such an abstract level that it's not quite clear whether this is all that helpful. And so the Patent Office did issue some guidelines, most recently in 2019, where it basically said that that a claim with judicial exception may be patent eligible if the claim recites additional limitations that integrate the exception into a practical application. Okay, so now we have the agency trying to bring some sort of more day-to-day guidance to step two by focusing on additional limitations. So you look at the claim language and you focus on whether there are additional limitations and whether then we find some practical application. So as we look at the cases post Mayo Alice that I'll discuss now very quickly, you see some sort of test like this emerging in terms of the search for a practical application that's being recited within the claims. So we mentioned the Ariosa case. In Ariosa, the question was a method for detecting fetal DNA in the mother's blood serum or plasma. So the idea is that instead of trying to obtain a DNA sample from the developing fetus, there is a way to isolate fetal DNA from the mother's blood sample. And this was a way to test for things like Down syndrome and other potential genetic issues. So this was found to be not patent eligible. The court, and again, Dr. Singh cited the language from Lynn, this was simply identifying a natural phenomenon. It was simply a way of looking at the blood serum and identifying DNA, but the court did not find this to be specific enough. It was just simply viewed as a natural phenomenon. Sort of, again, a mix of natural phenomena exception and the exception for abstract ideas. Then you have a bunch of cases that are more recent. Ariosa was 2015. You have Vanda Pharmaceuticals versus Westward Pharmaceuticals, where you have a genetic test to identify poor metabolizers. So patients who had very weak metabolisms, and then adjusting the dosage for the patient with the poor metabolism. And much of this might sound a bit like the patent at issue in Mayo, where again, the idea was to identify certain reactions, certain indicators or biomarkers in patients, and then adjusting the dosage based upon a correlation between how the patient was reacting and the likelihood of the drug being effective. But here the court does find it to be patent eligible. And I should emphasize, all of these are Federal Circuit decisions. These cases have not been going to the US Supreme Court for various reasons that we can discuss. Here, the court's reasoning for why this was patent eligible is that here we have a specific method for treating a specific patient using a specific compound at specific doses to achieve a specific outcome. Again, I was taught when writing not to repeat a word, but I guess rhetorically, there's effectiveness in repetition. And obviously here, the court wants you to focus on the word specific. And so this is, one of the things that's very interesting about what's going on with patentable subject matter more broadly, how much of this has to do with the claiming language, right? So I believe it was Judge Rich from the Federal Circuit who said that in patent law, the name of the game is the claim. I think specifically he was really talking about patent infringement, but much of this, at least in US patent law, is about how things are claimed. The claiming language becomes very important, and we see this in patentable subject matter. You need to have your claims to be very specific. And here you see the specificity for diagnostic patents have to do both for the specific method, a specific patient or class of patients, a specific compound that's being used in the diagnostics, and then the specific doses and the specific outcome. I guess the court is emphasizing the more specific, the better. And so you see a similar result the same year in Endo Pharmaceuticals versus Teva Pharmaceuticals. Here you're looking at creatine clearance when you're looking at renally impaired patients. So you're again dealing with kidney disease here. And the question then, of course, is adjusting dosage. So you have the diagnostic based upon how well the patient is doing in clearing creatine, how the body is reacting, how the body is processing, and then adjusting the dosage of the drug in order to deal effectively with this particular patient. And here the court said this was patent eligible. An idea was to incorporate additional features related to the treatment with practical applications of the underlying natural phenomena. So again, additional features in the claim related to the treatment, and the emphasis here on practical applications of the underlying natural phenomena. So again, what we're looking for when practical application, again, what does that mean? How practical? All of this is practical. Patents by nature are practical in some sense. But the court is concerned about the patent being so broad that it just has too broad a scope, as we'll see. And so the most recent case is this Illumina versus Ariosa case. And this is interesting because we now are going full circle to the Ariosa patent. Here you have the Ariosa patent at issue again, but different claims. And remember, in the Ariosa invention, the idea was to identify fetal DNA using a mother's blood sample rather than simply looking at the fetus directly or extracting a sample of fluid from the fetus. And so here, the particular claim was a way of method of preparing a fraction of DNA enriched in cDNA, extracting the DNA from, again, the mother's blood serum, producing the DNA fragments by size discrimination, and selectively removing the DNA fragments above a certain size. Here, this was found to be patent eligible by the Federal Circuit. Here, the court says you have a specific process for identifying the steps of size discrimination and selectively removing the DNA fragments above a specified size. It also includes physical process steps that change the composition of the mixture, resulting in a DNA fraction different from that naturally occurring in mother's blood. So here, again, the emphasis is on specificity, and we come full circle in some ways from the 2015 decision 5 years earlier, where the court found that certain other claims in the patent, the Ariosa patent, were not eligible because they were not specific enough. So let me conclude by talking about the policy concerns, and this may be more interesting, I think, than thinking about what are rules, what are exceptions, and how do we understand what those mean and what the court is trying to do. The concern, of course, is that process claim, if too broad, can preempt a field. It can affect how doctors operate. It can affect how further medical research is undertaken. It can affect how individuals in the ground who are trying to diagnose particular types of treatments and tailor particular treatments act. And so there is a concern about that from a policy perspective. And therefore, in terms of looking for patent eligibility, we want to make sure that there are identifiable limitations within the particular patent. And then the problem becomes of identifying when the limitations narrow the judicial exceptions. And the recent cases suggest that the courts are looking for, at least the Federal Circuit is looking for specificity, it's looking for practicality, but it's not completely clear what those terms mean. And I should add, it's not completely clear why something like an enablement requirement or a written description requirement could also not solve or resolve those issues. But there is a move with this patent eligibility requirement to try to give the patent office and the courts some guidance in terms of, at the threshold, trying to deal with patents that might be troubling because of their breadth. And this may be especially true in the medical diagnostic area. So that is my presentation. I'll stop there. Thank you for listening, and I look forward to further discussion.
Thank you so much, sir. And few of the, striking points out of your discussion or presentation was, first of all, every invention is based in some natural phenomenon, some, you can say, exclusions which are being there. And how you specify those, inventions. Specificity is the key. And as you said that the real essence of the success is how you draft that claim. So, if you provide that specificity, which go beyond the diagnostic methods or, these exceptions which are recognized, then it may be eligible for patentability. As you mentioned that in 𝐵𝐿𝑆ky case, MOT test, Justice Breyer's, observation was pretty catchy to me when he said that MOT test, that is machine or transformation test, may be one test, but it must not be a sole test of, judging the invention, because we are living in an age which is, encountered with different nature of inventions, which are not tied up to any machine or which is essentially transforming something. So, I mean, in US, that is the beauty of that very judicial system, that it evolves time and again, try to rectify those situations through judicial decisions. And the sign is being, coming, as you have just mentioned, the later cases, just, 2020 case. And there is a glimmer of hope of that. And I think that, that may be paving way for diagnostic patents and giving hope to that. Having said that, if you compare this very situation to the Indian patent law, the term is used that what are not inventions, rather than what are the exclusions to these inventions. So there is a, you can say clear difference. And if you go literally by this very thing, there is a dominant impact on judging the invention, that if the term diagnostic is used, you are not moving forward. You are just sticking to that very point because it is just, explicitly mentioned that diagnostic patents or diagnostic methods are not patentable. So whether you are, as an examiner, as you said, that examiners are needed to be trained because they first encounter the invention. So, at that very level, we will be, taking insights from Dr. Kardam also. But I'm just, pinpointing this very thing is that who is going to make a change, who is going to pave the way, whether it is only judiciary or, the administration which is looking after these things. So that must be a very, interesting scenario to look into. So thank you so much for your insightful presentation. And now I'm inviting Dr. Malathi Lakshmikumaran, and because he was practicing for a long time, and she was, encountering with so many situations with the patent office or with the courts. So she might be providing us a clarity whether our approach is very, very right or we need to change our approach. So I'm just giving a brief profile of Dr. Malathi. She is an executive director and head of the life science group at the IP division of the firm Lakshmikumaran and Sridharan. And she is also a registered patent agent, and she is actively engaged in preparing, filing, and prosecuting the patent applications. So the thing that we were talking about, how to draft the claims and whether the claims are appreciated or not, that she will be explaining to us. Apart from that, she's also actively engaged in biodiversity and traditional knowledge discussions. And she supervised many students, PhD students in the area of plant molecular biology. And she served as the head of Center of Bioresource and Biotechnology Division in TERI. So with this, I am just inviting Malathi ma'am. Please, the floor is yours.
Yeah. Thank you, Raman, Mittal, and Kshitij for giving me this opportunity. It was great hearing Shubha, Ghosh, and I'm not going to waste too much time, and I'm going quickly into what are the issues or what are the problems that we are facing in India. So I will quickly say what are not inventions. Kshitij, you said correctly, and we're only looking at section 3I. And the whole confusion came up because in 2002, with effect from 20 May 2003, the Act changed with respect to section 3I. It says any process for the medicinal, surgical, curative, prophylactic. It didn't was there. The diagnostic and therapeutic terms were added. And that led to a lot of confusion because first it was very clear: medicinal treatment, surgical treatment, curative treatment, prophylactic treatment. So something that you treat, something that you can be prophylactic, like vaccination and so on. Therefore, here, when you add the diagnostic therapeutic word, can you read it separately? Should it be read as medicinal treatment, surgical treatment, curative treatment? Because all these, which are shown in blue, is to be taken together. And therefore, when I read it, it looks like any process for the diagnostic treatment, because it's an or treatment of human beings. So the first part is with respect to human beings. The second part, or process for similar treatment of animals. And there, when it came to animals, it said to render them free of disease or to increase their economic value or that of their product. Therefore, here by adding this term diagnostic, therapeutic treatment, I can agree. But what does it mean, diagnostic treatment? But most of our examiners most of our controllers only look at the word process and diagnostics, and they say it is a diagnostic method, and therefore patents are not granted. This confusion, and we need clarity on that, and we don't have case laws like what Dr. Shubha said that they have in the US. We don't have that. Why did we do all this? Because in Article 27 of the TRIPS, we had diagnostic, therapeutic, and surgical methods for the treatment of humans and animals. So member countries could exclude diagnostic, therapeutic, or surgical methods. Now, the methods of treatment, which I call as MOT, are available in US, Australia, and New Zealand, but not in many countries. I've just taken some. I looked at the EPC 52.4, then it became 53C, where it was clearly stated that methods for treatment of the human or animal body by surgery or therapy and diagnostic methods practiced on the human or animal body shall not be regarded as inventions because they're not susceptible to industrial applications. Later, it was actually because of a public policy of trying to more on public health. You didn't want to go after doctors and so on. But anyway, it remained like this as 53C. So it is very clear in EPC, diagnostic methods practiced on the human or animal body. So in vitro test or ex vivo test definitely is patentable. But if the test is completely taken on the human body, like I do an allergy test, I prick a skin test, I check what it is, everything is conducted on the human body. Such things will be considered as a in vivo test, but all in vitro, ex vivo tests are excluded, and these are patentable eligible matter. The provision also said that it will not apply to products in particular substances or composition for use in any of these methods. I'd just like to say that where does the issue rise? I'm going to give some classical examples. I've just done some study. These are all rejected patents at the patent office. So surgical methods, I agree, surgical methods, even before the 2002 enactment, surgical methods was not patentable eligible, was not patentable subject matter. Because of the word diagnostic and therapeutic inside into the section 3I, that's where all the things arose. Surgical methods, some of them are not patentable. When it's isolation of bone marrow, a skin for surgery through surgery, those are not. Any therapeutic methods, like you have claims or methods for treatment using compounds or a combination vaccine regime with an administration in pigs was not patentable subject matter, or anything which is performed on the human body, where it was administration of curcumin followed by in vivo retinal imaging was not patentable, and it was refused. There were also single administration dosage, and it was given in vivo. That was also not patentable subject matter, and refused, which is okay. But what happens in diagnostic methods? As I said, we need to look at our act in such a way that the first set have to be read together, and you cannot just use the word process and diagnostics and say, I will not give you diagnostic methods. We do have some more where you're diagnosing for liver fibrosis or for COPD diagnosis. Even such things are not patentable in India. I just quickly want to tell today in the COVID area, we have a lot of people, lot of scientists in the Indian public sector, private sector, coming up with tests. And these could be RT-PCR tests, or they could be ELISA tests to detect COVID-19, or to look at either through ELISA methods or RT-PCR method, or even CRISPR-Cas. We have this Sherlock, which is there in the US. We have Feluda in India, using CRISPR-Cas to detect. What happens to all these things? They will not get a patent. So this is where we have a problem between diagnosis versus detection method. The Manual of Patent Office Practice and Procedure clearly said a diagnosis is the identification of a nature of medical illness, usually by investigating its history and symptoms and by applying such tests. Whereas what does our section 3I say? Does it encompass detection tests, screening tests? Suppose I want to check the level of sugar. It doesn't tell me I'm diabetic. Okay, so does it encompass that? A screening test, a detection test, an in vitro test, an in vivo test. So when I do talk to a lot of the controllers and I'm a practitioner, in India, we don't have what happens in the EPC 53C, where it says diagnostic test practiced on the human body or animal body. We don't have that. So we don't have a distinction between in vitro and in vivo. We don't have a distinction between in vivo and ex vivo. And because of the term diagnostics in section 3I, which has led to a lot of confusion, ambiguity, hence all detection tests, whether they're diagnostics or not, for screening, prognostic method for assessment of disease progression, all these are considered as diagnostic methods and we don't get a patent. However, I looked at some of the patents were granted. So it's not that we have completely no. And here I looked at this, what were the basis for these grants? Here, this was an assay, wherein the assay is not a method of diagnosis of an ailment associated with a human being or an animal. They put a disclaimer. Now, just by putting the disclaimer, if you can get a patent, many of us would do that. But it is also very much dependent on controller to controller. Another one, which is a method of determining a value indicative of viral infection in an untreated whole blood sample. It got the patent. There were in vitro methods, and they said it's in vitro. We are using body fluids of a patient for the testing of bacillus, and the patent was granted. In some of this, the term diagnostics was deleted, and it was the phrase providing a sample of a body fluid from a subject suffering from primary non-infectious disease got a patent. So we do have some patents granted, and there have been, if you look at the prosecution history, there have been some reasoning. But then we need this ambiguity, we cannot live with it. Because a lot of the applicants will say, oh, similar patent has been granted, why are they not allowing for my cases? There are some rejections, even, and I'm only talking about diagnostic. I'm not talking about treatment, surgical, medicinal. We're only talking about diagnostic treatment, diagnostic methods. Again, there was another one which was rejected because of the HBP levels and the prediction of severe sepsis. And it was interpreted as a method of diagnosis. We had a patent application for the presence or absence of chikungunya. Of course, it was using ELISA method. People use antibodies to do that. And it was not accepted, even though they argued very well that this is an in vitro test. Just by testing, I cannot say that this is a diagnosis. I'm only saying whether you have the presence or absence of the virus, but it was rejected. There was another rejection, which was an in vitro method, which was for detecting the fragmentation of an adiponectin receptor. And again, the patent office clearly rejected, saying we do not have a distinction between in vitro and in vivo methods, and therefore we refuse the grant of the patent. Therefore, what do we want? What is it? Can we have in vitro methods allowed? Can we say it is not diagnosis, but it only tells you the level of a substance or a protein or a marker? What is the distinction between detection and diagnostics? What is the difference between, can we get in vivo? We cannot get in vitro, we can get ex vivo, we can get. And also this recitation, that is, render them free of a disease to increase the economic value or that of their products, is specifically with animals, but it's many times also interpreted along with the detection assays for humans. So there is a lot of ambiguity in this, and the ambiguity is, again, I come back, because of these two terms that was added within this phrase, I would say, because it doesn't make sense to say that you have diagnostic treatment, but that is not how the patent office is reading. And they are also confusing with the second part, which talks about similar treatment of animals to render them free of disease or to increase their economic value. So is it that surgical methods, I do a facelift, or I do a plastic surgery, or I want to change my nose, or I want to, I'm getting old, I need a facelift. Will that be allowed? Because it is not a treatment to render myself free of a disease. There are confusions, and these confusions have to be erased. We need some judicial precedents to be clear on where we are with respect to diagnostic methods. Today, the world is moving. We have to be at a very fast pace. If we don't incentivize Indian inventors by getting them a patent for testing of COVID, we may have some new this thing. It will be very difficult for people to get patents. And if you don't get patents in India, where is the incentives for you to come and work in this area? Therefore, we need to have a fine balance between public health, social, economic growth of the country, and we need to support medical technological innovation to be competent and survive in the global scale. And therefore, with this, I will stop. But what we want is, can there be more clarity? Can there be some case laws so that we're clear what is allowed and what is not allowed? Thank you, everyone, for a patient hearing, and I will be happy to answer any questions that may come up.
Thank you so much, ma'am. And you have earmarked the two terms like detection and diagnosis. And even in detection also, every detection is not rooted to diagnosis. So that very clarity must be there to find out the human ingenuity ingenuity, to appreciate human ingenuity, where there is a case, clear case. And I think that they have provided clearance that in vivo and in vitro maybe, shall be excluded. But more clarity could be brought through other, guidelines also. Like, you cannot reject these inventions or the processes which are involving diagnosis in such a blatant manner. You need to have something which you must look into it. The other thing is that one of the policy reasons which I am just, expecting from this very section is, and why diagnosis has been excluded from the purview of patents is the larger social interest that must be available to everyone, because it is so basic and so at the core of the medical treatment. So one of the reasons may be like that, but one has to look into that very thing, that whether it is totally aligned to that or it is doing something at the intermediary level. So, if you go by the cases all around the world, they chalk out this very thing, that whether it is working on an intermediary level rather than resulting into, in diagnosis in a very strict manner. So this very clarity, I think, could be provided with the deliberations, discussions at every level. So I hope that this is one of the initiatives which we have taken. So we have to deliberate it through various stakeholders, like through government, through industry people, and through academia. So I'm very much thrilled by your discussion and presentation. So thank you very much, ma'am. And the best person to answer this question is around us. So he has been responsible for a long time, and he did a very great job in making the ecosystem, first of all, the patent ecosystem to work in such a way where you need not to go and attend the hearings physically, but you can do that online also. Apart from that, he has improved the whole, you can say, systematic structure. So I'm next time inviting Dr. T.S. Kardam, and he has his base in academia, as you have. So because of that, he has those, he understands those nuances which are coming at the, on the convergence of industry and academia, as well as government. So Dr. K.S. Kardam was a former, is a former senior joint controller of patents and design at Indian Patent Office, New Delhi. He has a vast experience of 37 years in services, legal service industry, especially in intellectual property rights. He is skilled in patent litigation, international IP law, patent prosecution, competition law, and legal research. And he has a master's degree as well as PhD from Delhi University only. So, and he did his law also, I mean, from Law Center 2, from our university only. So it's a matter of pride for us. So without further ado, I'm just inviting Dr. Kardam. Sir.
Thank you, Professor Kshitij Kumar. And first of all, I would like to convey my sincere thanks to you and Professor Raman for this important, for discussion on this very, very important topic, especially especially on diagnostic methods under Section 3I of the Act. And I would also like to thanks Professor Ghosh for his excellent presentation and gave an overview of US system, how these issues are dealt with in US PTO as well as US Supreme Court. And Madam, also I would like to thank you to reflecting the pain of patent attorneys and other stakeholders in India with regard to this particular important subject matter and highlighting your issues. And I tell you, this is very, and this the timing of seminar is also very, very important. You know, when India is, in WTO there is a proposal for IP waiver, and we are struggling to, conduct to have a test result of COVID in 48 hours. You know, we are thinking of our scientists are thinking inventing kit or a tool so that tests are conducted and results are out within 5 minutes or maybe 10 minutes, not to wait for 48 hours for such important infection. So I say this is very, very important, and let's understand the importance of this subject. When I was hearing the the presentation of Dr. Ghosh, I also, in 2019, when Supreme Court, US Supreme Court, got confused about the diagnostic methods, in one of the cases, Athena Diagnostic versus Mayo. So where the Supreme Court, the 50-50 finding that 50% of judges were in favor of the grant of that, rejecting allowing that particular patent of Athena, where the 50% judges, but ultimately they refuse, and they, also US people were also excited to have some new guidelines on this case. So when the US Supreme Court can have a confusion on this particular important issue, the Indian Patent Office should not be an exception to that. So I think this is a very, very important issue, and in the Indian scenario, Dr. Malathi Kumaran has explained the various cases where the examiners have, rejected certain cases. But I was surprised to note that there one case which she mentioned, that the examiner asked the attorney to delete the word diagnostic, and they got the patent. So this is really amazing. If you delete the diagnostic word, the method remains the diagnostic method, even if you delete it or let it be remain. So one has to examine whether this is really a diagnostic method or something else. So diagnostic method, as you know, already I think our manual, it is very, very clearly explained, and Madam also read out in the presentation what the what is the diagnosis, the word. So So diagnosing, identifying the disease in a human being based on the test conducted. So, as far as the diagnostic tools are concerned, kits are concerned, I think there is no doubt. But still, even then, there are certain kind of diagnostic kits, they are also not allowed when these diagnostic kits are, attracting the provision of Section 3F, where the arrangement and rearrangement of known devices, when in a one container you fill one solution, another container you put fill up another solution. So the kits are also, diagnostic kits are also sometimes difficult to get patent in India because of the Section 3F, because they are all work independently. But there's only first case, I think, in India where the diagnostic kit, where the certain, based on certain methods, which was allowed, that was related to the identification of hepatitis C. The J. Mitra versus Kesar Pharma diagnostic. So this is the first case which the court upheld that kind of kit, where the different kind of containers having different kind of buffer solution and certain things, and when they put drop by drop, the 3 drop, 4 drop, like that, there was a method, and that method also a kind of diagnostic only. So, but this overall, patent was related to the diagnostic device. So that patent was upheld by the Delhi High Court, considering the various containers and all. But all said and done, it was held valid. And since then, I think the diagnostic kits are getting patent in India quite faster without much problem. But the only area which remains to be is the diagnostic method. So diagnostic methods certainly are concerned, and moreover, in India, there's no legal case law so far. And I think the year ago, who knew that in computer software patent related inventions, hardly there was any patent where the software was inbuilt, and the patent, even though there is a technical advancement of the matter, but most of the computer related inventions were rejected in India. But in the last year or so, where when Delhi High Court came and explained that these are the parameters for considering the computer related inventions, where the software is main, which can change the functionality of the hardware. So they have, clarified a lot of things, and now it has become quite easy, and they are even IP office has also streamlined their procedure in granting the computer related inventions. So that now, because of in this particular area, there is no such case law so far. I think, and that's why the guidelines, the examination guidelines for pharmaceutical product, even the manual, are just limited to certain basic understanding which a common person can understand. Like the definition, they have taken the help of dictionary meaning of the certain words, and also the practice followed in the past. But they have, the IP office, as so far as I understand, they have no guidelines from the court so far. And because of many attorneys or many companies or applicants have not gone to the court on the refusal of their patent application on the methods relating to diagnostic or maybe other kind of treatment. So this clarity will, I am sure that it will come moment there are some cases, as we have noticed in the computer related inventions. And as far as the analogy to exclude why, as the Indian patent law, even in 1970, there are certain I mean, process of treatments where they were excluded. But when the TRIPS came into being, as Malti madam has also explained, and that's the reason why they are also included in our definition. But maybe the placement of, she was questioning the placement of these two words in the this thing in the section 3I. I think as far as I understand, there's no, I mean, you know, I think they are very clear. When you read the treatment of human beings, similar treatment of animals, so the economic value of animal is increased. So this cannot be in case of human being. You know, the last paragraph, the other treatment of animals, similar treatment of animals, increasing the economic value. So what economic value of human being cannot be changed. It can be changed in the animals. Like if you make some treatment of, I mean, chicken. So like they grow within 2 days. I mean, they become full chicken, you know. So maybe that kind of economic value of those animals like goat or maybe a lamb, something like that, which are under commercial, channels, you know, where they are a matter of commerce in the market. So if you remember, before 2001, there was hardly any case of biotechnology where the living material was involved in the patent claim. The Indian office was never, granting any patent. They were questioning only that there should be some substance. That means non-living substance. If something is living there in the composition, they refuse. But in 2001, the Calcutta High Court, first time ever, they examined the issue and they granted they said, no, the office is wrong. So I think similar way, we have to find a solution in the court, and it depends on the attorneys or the applicant who can take the risk of going to the court and get the clarification. I mean, most of whether it is a patenting of living organism or whether it is a patenting of software related inventions, I think that the IP office have been guided by the courts and they have changed their practice. And I agree, there are many patents, I mean, they are refused by the office, especially there is a method relating to the diagnosing the liver fibrosis in a human being. So naturally, the liver fibrosis is naturally has to be conducted. So in US, you know, or even sorry, the European patent convention, the wording of the section is very different than in India. So there the wording is the practice on human being. And so, but that kind of wording in India is not there. So that means the treatment of human being. So treatment includes maybe diagnostic treatment also. Diagnostic, although this may be a treatment to find out. I mean, if there's somebody's treating certain things like taking out the blood of a human being and then diagnosing the things, and then then he identifies certain disease. Oh no, this thing, and based on he predict, the doctor predicts. So probably these methods are exclusion of these methods based on the public policy to protect the general public, and so that the benefit can go to larger public interest, you know. So that's the reason why the Indian law is slightly different than European Patent Convention, where these words are not similar to same as of the US EPC. So that makes it quite difference between Indian practice and European practice. European practice is also quite clear. They have, like in US, Dr. Ghosh explained the two-step process. There is a four-step process in European Patent Office. You know, whether this is what are the tests and if they conduct the test and they compare with the known database of such those things, if there is a variation, whether that variation has contributed certain development in that. So they have a quite developed, I mean, their courts as well as the board, they are, I mean, they are very clear. And I think in India still we are missing the legal, I mean, judicial pronouncement on these issues. So naturally, I say the patent office is being guided as on today by the manual as well as the guidelines on examination. So because of the lack of judicial pronouncement on this important issue, I think this will continue until somebody goes to the court. But I feel like I do agree that these are the methods sometimes very, very important, particularly in the situation where we are facing pandemic situation. Today is a COVID pandemic. Maybe who knows, after 100 years or so, next 100 you may have different kind of pandemic. So these diagnostic methods are very, very important in controlling the infection and all. And I feel there should be some legal pronouncement by some courts. Then only the situation in India will be very, very clear. So the Indian law as stand or Indian practice as stand today, they basically the treatment, the diagnostic methods are equivalent to treatment they consider, as also the definition which is given in the definition of diagnostic identification of the symptoms, and then based on the symptom the prediction of the disease or prediction of the treatment. So based on these two things, still India continue to analyze the legal issue. And I think more than that, I think I can't say because of the current practice is like that. And I am very hopeful that in a time to come, certainly somebody will make effort, or maybe Ms. Malathi Kumaran will be the person who may go to the court and bring some good orders and good directions in this regard. Thank you.
Thank you so much, sir, for clarifying various issues and putting it forward as a final interpreter. Courts are always important, court decisions are always important. But the painful thing is that, I mean, sometimes you are, I mean, exposed to certain situations where you need to expedite your process. And you can't wait that, I mean, the courts will decide, then you can go and, I mean, proceed further. So, I mean, there may be another way around, as Professor Ghosh was mentioning, that there were certain agencies which were just assisting all the agencies, may it be examiner, may it be any other entity. So at the very initial level, let go for, I mean, these things as per your claims and as per your, I mean, drafting methods, and give a test. I mean, you have to proceed first. And I mean, as a professional, if we talk about Dr. Malathi Kumaran, I mean, Malathi Lakshmikumaran, then she may also be hesitant that if we will be unnecessarily putting burden to our client, that there is no clarity as such and the chances of getting rejection are very high. So there may be some reluctance on her part also, that how can she proceed. But I think that, I mean, these communities as we are forming, I mean, we can reflect something and we can write up, or you can say reflect certain literature, which could also, I mean, bring some change, I mean, in that way, that I mean, just, you know, familiarizing these things to those people, or getting them aware that you must understood in that manner. So I think that it is the examiner who must not be pressurized to the very, very rigid terms which are being used. They must be given that very flexibility that they may proceed further and have the rejection, let the things come, and then we will see how the courts will decide. I mean, what China is doing, if you see, I mean, we cannot appreciate everything about them, but one thing is very clear that they are giving way for inventions and they are very welcoming to these inventions. So because of that, I mean, if there are rejections, they are very ready for that. In US also, I mean, they were flooded with various applications which were patent trolls. But after that, I mean, when they tightened up, they, I mean, make this thing very streamlined, as well as at least they have put a move on to these conditions. So my point is that, I mean, we should all join hand together, then and then the things will change. As you know, the courts are always facing some time trouble and it takes like 3 years, 4 years. Take the example of Monsanto case. Once it reached to Supreme Court, then it reverted back to the single judge, and then we are still waiting. What is going to happen? So these are the things which are there, and I'm just welcoming everyone if for the final observation if you have. So please, sir, or interact with each other.
I would just like to react to what you have said.
Okay.
I agree, because as I said, this area is very, very important and has huge potential, the diagnostic area, huge
Yeah.
potential, not only in India and I mean globally. So I think, as you said, the positive move is required in IP office. But thing is that who will bring the move? So
Yeah.
now, so there's some based on the foreign case laws, something has to be done, whether this is right move, and some flexibility should be given, and I think some creative mind has to come and do some study and come out with a good decision, so but because now the IPAB also dissolved, and I think the final burden which I feel is on the now courts, high courts, to come out with such a important topic, some issues, some guidelines. In case, this is not a question of burden on the clients. If the clients invention is quite potential important and it has a market, I think they can afford to go to court and bring out the order or the guidelines, which may be very, very important, and that can set the line straight and for everyone, including the IP office in future. So let us wait for that moment, and I'm sure because the IP is becoming very, very important in the pharmaceutical sector, especially the diagnostic sector now, because we have a lot of devices, medical device, and that includes diagnostic device, and also they are used. I think this one day, days are not very far when you have India law, Indian judicial pronouncement on these issues.
Thank you. So if you said very well that one has to take risk if he wishes to have something. So that's a good logic. So there are a few questions. If I mean, Malati ma'am or Professor Shubha, if you wish to have final comments, then I will be picking up few questions.
Okay, sure.
So should I go by the question and then?
Yeah, I think we can go with the questions.
Yeah, go with the questions. Otherwise, we'll just be talking more.
It's already late. Yeah.
So
Kshitij, you can ask the questions.
Yeah, one question is that could anyone explain how in vitro fertilization, genetic screening of sperm and egg do not hit by diagnostic approach? This is by Bhaskar.
Yeah, I mean, I think Dr. Kardam also explained, I'm Malati here. This will be difficult for you to get a patent because you can have 3B rejections. And actually doing it on the human body, taking out the egg and freezing it and treating it. So we will have issues on 3B. It is not basically a diagnostic one. That is more a treatment and in vitro fertilization. And there definitely it will come under any surgical, medicinal, therapeutic. It is not a diagnostic treatment. It is not a diagnostic method. So that to get a patent on that may be very difficult. You can get devices to be used for in vitro fertilization. So I always give this example of angioplasty and angiography. Angiography is just the diagnosis. You're checking. Angioplasty is where you insert the stent. The stent is patentable subject matter. It could be drug-eluted stents or any of those are patentable subject matter, but the method of doing angiography or angioplasty may not be patentable subject matter. So unless we know the facts, this may be a little difficult. IVF, definitely India will not grant.
So then you can
But the devices and all can be like lasers. Laser surgery may not be, but the laser device, robot, those are all patentable subject matter.
And I think, I don't know which aspect of this question is aimed at for IVF, but much of this is fairly known technology, at least since the 1970s. So I'm not sure how much would be novel at this point. So I mean, there would be novelty. I'm not denying that. I'm just wondering exactly which specific aspect of IVF the questioner is asking. And I guess I'll use this to think about one point that we haven't really discussed, and we've talked very abstractly about patents as incentives and the need for this. Obviously, everybody recognizes that, but there are lots of incentives in addition to patents, as we also know. So I guess the question is, how do you create a system that's very practical? And that really boils down to why, what is the decision making for, what people decide to invent, and how then they decide to pursue their marketing strategy, which may or may not involve a patent. It may involve trade secrets. It just may involve, extensive contract or licensing, provisions, which may need some patent law to support. But I think we tend to think about patent as the fulcrum for everything, without understanding it more practically. And I view a lot of these exceptions. I mean, the 3I, the 3B that was mentioned, they are representing some broader policy concerns. But then how do you translate these very kind of broad, almost moral policy concerns into the very practical? I mean, you could make the argument that not allowing the patents also have, moral effects, because not having these inventions can affect whether people live or die. So I think it's a very complex, abstract set of questions that we're discussing, and I'd like to see more focus on just the very practicalities of why we need diagnostic patents and what do the companies view. I mean, I think a lot of these companies that have the patents, they're obviously doing research in this area. They're trying to demarcate some space in the marketplace by which they provide these particular services. And so we need to maybe think about the patent system with that in mind. And my view is that patents should be narrow. I mean, I think they should cover a very specific invention rather than trying to be very broad. And this is really the heart of the problem, in my opinion, that when you're a patent attorney and you're representing the client, at least we think about the client interest is to try to get as broad a patent as possible. But really the interest is to get a patent that suits the client's needs in terms of meeting the specific invention that they've had. That may be a controversial statement, because I think it seems like the attitude is to try to patent broadly, but somehow a medium range or even a narrow range patent would be better. Now, usually the criticism of that is, well, that maybe you get something like patent tickets, so you have too many patents. So you have, for example, a complex technology that has so many different facets to it, and then you'd have the patents on different narrow aspects of the technology being held by too many people. That may be an issue, and this is really the question of what the proper scope or scale of a patent should be. And maybe that's the way we should think about this patent eligibility question. rather than, I'll be blunt, rather than the more moralistic terms in which we have been thinking about.
Thank you. So should I move to another question?
Yeah.
So Mr. Srikanth has made he seeks some clarification regarding what do you mean by the increase their economic value or that of their products mentioned in section 3I. I think you have explained a bit, but if you...
I think this is more connected to the treatment of animals,
Yeah.
where the economic value of a product or animal is increased, if there is some treatment, if you treat an animal which can become fatter, which can, you can increase their weight, you can increase their growth, and that's how their economic value is increased. So I think when you have a poultry farm, poultry farm where you need this kind of treatment, you need some kind of a product where you can give to as a feed to them, and so that they become fatter. So I think that is an economic value which I understand from the more. It is not related to human being. I tell you, I am very sure. So it is
Yeah.
only in the context of the animals.
Yeah. No, I agree with Dr. Kardam. So it has to be read as the first part for human beings, and the second part is similar treatment of animals. And so from there, it is similar treatment. So I have a question for Dr. Kardam. That diagnostic word is not there. It says similar treatments of animals. A diagnostic detection kit cannot come as a treatment. So will detection tests for animals be patentable subject matter? Because we definitely have in 3I one for humans and the other for animals. And I'm also happy to state that the word plant was there in the second part, which has been deleted. And we are getting patents in the field of detection of plant virus or a plant improvement or any assay with plants. That is not a problem at all. But we are still facing problems for diagnostic assays or detection for animals, though it says similar treatments. And the second part clearly says it is treatments. And therefore, the way we interpret this, there isn't any diagnostic detection, which is a treatment.
Diagnostic, as far as, because of the word similar treatment, so because of the word similar treatment, diagnostics are also covered under that. Diagnostic methods are also covered. But as far as the economic value is concerned, the treatment, whether it's a diagnostic or otherwise, when you are increasing the economic value of a animal, then in that case, diagnostic methods also not, not patentable in that. Similar treatment,
But a diagnostic assay is not a treatment.
In case of diagnostic method practice on human being, you need not to prove that this is to increase the economic value.
Yeah, that I agree with you, because that is separately for animals.
Yes.
There are two parts to it. And the second part of economic value or render them free of a disease, that part is with the animal thing.
This is
so that is not with the humans.
In case of, this is in case of animal, it is a total exclusion. And in case of animals, I think when the treatment to increase their economic value.
Okay.
Right. So it is slightly, in case of animal, it is lesser, to less extent, because of the two conditions in case of animal.
Okay. So this would be, I think, the last question, because we are running short of time, so we cannot take every question. there are questions about the robotics and all that, so that will be.
I think robotics are, they are very simple because they are a device. I think if the device are made to perform that diagnostic method, I think those devices can be patentable, subject to the conditions that these devices do not fall under section 3F. I mean, arrangement and rearrangement of known devices, working independently.
The last question I am taking up, and it is coming from Dr. Sridharan Kumar Singh. He is asking that several decisions of the Technical Board of Appeal of EPO, European Patent Office, are very clear on diagnostic and prophylactic issues. The ratio of decisions may be added to the Indian patent guidelines, and then it should be left to the court. But certain surgery of human beings also increases the economic value, 𝐂𝐻-𝐶 surgery done by actor or actress.
That is second question. First one. This was the reply of the Kardam sir, because sir, I read one case related to prophylactic and surgical issue in of Technical Board of Appeal. One was about the cosmetic surgery. So how you will draft the claim of cosmetic surgery? That if you are drafting that it is only for the cosmetic purpose, because obesity may result into disease, and obesity may decrease the economic value of any human being also. If in that case,
Dr. Amrin, as I said earlier, in case of human being, the examiner doesn't have to see the economic value. It is what are the treatments which are mentioned in the section 3I, all relevant.
That is true.
But
about diagnostic, sir, that means if they are performing surgery, so how they are drafting, that means if it is only for removing the fat, then it will be cosmetic, and if it is for the curing the disease, it will go into the prophylactic for future.
Whether it is a cosmetic surgery or whether it is non-cosmetic surgery, and surgery remains the surgery, there may be an invasive surgery, there is non-invasive surgery also, So, but surgery is surgery, whether it is for cosmetic purpose or other treatment purpose also, because it is being practiced on the human being. It is, in this case, when you interpreted section 3I, in case of human being, the economic value has no relevance to it. No relevance. So that is one. Next, I would like to say that because Indian decisions cannot be the same as in Europe, because the European law is slightly different than what is in India.
That is true, sir. That is true, but I think that should be incorporated in the light of Indian patent provisions. I am not saying that it should be directly adopted. So what maybe
he will be speaking. I think the others could also come in if they wish. And regarding your first part, I think you are suggesting that we have to look to other jurisdictions, which we are always looking up. And in this very context, it is relevant that EPO is very relevant because they are streamlined in such a way. So.
But Indian IP office has adopted many practices based on the EPO. They are more close to EPO practice than the US. I'm sorry, Doctor.
Yes.
Of course. Of course.
But when there is a difference in the language of the law, then there is a problem in adopting those guidelines of European patent.
Yeah. So there they say practiced on the human body or animal body. We don't have that word in our thing. So the controllers, whether it's in vitro or in vivo or ex vivo, they will refuse those type of.
And one more question is, sir, because these days there is a machine is coming. Machine is not a problem, but once they are putting the data of all diagnostics, that means all 4 steps what you said recognized by. That means from the checking of temperature of the body to the final deductive method, that what disease is there. For that purpose, now the machines are coming that they will say that, okay, what is the stage of disease, what is the life expectancy of a particular patient, and whole thing will be determined only by the machine. The machine cannot be patented. Machine can be patented, but the method by which they are deciding it, it will go under diagnostic method or it will go under the machine process.
So as long as the machine is indicating the results, I think there is no problem. You can continue to patent those machines absolutely under Indian Patent Act also, there is no problem. The diagnosis is the next step when there are results based on the, when machine is providing you the certain, indications. The next step is the diagnosis. That is done by the doctors based on the indications in the machine.
Okay. So,
but you're envisioning the situation where the machine might itself be doing a diagnosis as well.
Yes, sir.
Right?
That is my question.
So, yeah. So when there, I think there would be an issue about whether that would be patentable. I mean, I guess it depends upon, the machine, when it's making a diagnosis, is largely engaging in the computational process. And so there is sort of an interesting question about whether computational processes are patentable independent of themselves. I don't know under the statute. I think the Indian statute is probably more forgiving to computational processes, but in the US, the mental steps doctrine may limit whether these pure computational processes are patentable or not. So that's an interesting question, but it largely depends on what the process is that you're describing for the machine to be operating.
Yes.
Right, because the machine, presumably we're not at the stage where the machine can be has the same reasoning capacity as the doctor. So when it's making its a decision about diagnosis, it must be doing something computational, right? So, one comment about the EPO, just to I know we're running short of time, but it's not surprising that the Indian Patent Office has followed more the EPO because of the statutory. I mean, as I've tried to point in my talk, the Patent Act is very thin actually in the U.S. I mean, it's not as complicated. I think students get, when you teach intellectual property, and there's students who they come in saying, "Oh, I'm going to love copyright," but copyright law is just so many exceptions, partly because it's covering so many different industries, and there are all sorts of different exceptions and limitations that the students have to sort of deal with, and there's so many different ways in which different types of works can be copied and distributed and displayed. Patent law in the US, the statutes are very straightforward. I mean, anybody can read them, I think. The problem comes with the judicial interpretation. How do you apply it to certain facts? And the courts may not have. And we can argue about whether the Federal Circuit and the Supreme Court have made it better or worse. I think Dr. Kardam made the reference to the Athena decision. That was a Federal Circuit decision where the Federal Circuit was completely split. And they were seeking some sort of guidance from the Supreme Court or from Congress. But I think it's unlikely that Congress was going to legislate. I think Congress in the US, the legislature, the parliament, that's what I mean by Congress in the US, is very hesitant to become more strict with respect to patent law, just because of just the politics of patenting and manufacturing and economic policy in the US. They're not going to do that. I can't think of any constituency that really is going to be do the kind of things that the court in Athena wanted the court, wanted Congress to do, wanted the parliament to do. The times when Congress has been very active, when the legislature has been more active with patent law, we have the American Invents Act, but that was viewed as making patent law more friendly. I mean, that people don't view it that way. Some people don't view it that way, but certainly it was meant to encourage patenting and try to be more consistent with practices in other countries, such as moving to a first-to-file system rather than to rely solely on a first-to-invent system. And the other area where the legislature has been active historically, in recent history, is with respect to generic drugs and the Hatch-Waxman. But that was an unusual circumstance in the 1980s, where the idea was to generate competition within the pharmaceutical industry. So those again viewed as a pro-industry type of legislation. But the types of things that the Athena court is asking, I think would be interpreted as limiting industry, and therefore it would be very difficult for Congress to enact.
So thank you very much, sir. And I will be inviting Raman sir if he wishes to say something.
So thank you very much, and it was such an invigorating discussion, so meaningful. I thank all the speakers, and I'm sure that all the participants enjoyed and they have benefited by the discussions, as I have benefited personally. Thank you so much.
Thank you.
Thanks, everyone. Thanks for a patient hearing.
Thank you, everyone.
Thanks, everyone.
Thank you, Dr. Ghosh.
Thank you. It's nice to see everybody.
Thanks, everyone.
Thank
Bye-bye.
you, Doctor.
Bye bye, man.
Bye-bye.
Bye-bye.